Okay, everyone, greetings. This is Tonson Fairmont with Brilliance in Commerce. We have the Natural Law Trust webinar today. Welcome. Thank you for joining us. It is June 16th, 2021. And wow, what a change going on in the world, isn't it? All the truth pouring out, all the consciousness rising, and the gradual diminishment of a multi-thousand year dark age. So we appreciate you participating with us with an asset protection instrument that is helping people to remain safe and migrate through this time with a kind of trust that can go on generation after generation, century after century. So Brilliance in Commerce is a project of La Verite, House of Freedom International Natural Law Trust is our topic today. We also have the Liberty Debt Elimination System and affiliations and special offers that you may have seen on the website. We're members of the Worldwide Charter for Fair International Commerce, and that is also on the website if you'd like to review it. We have a lot of principles that we adhere to, and we're very proud of that. Today, again, June 16th, our next trust webinar with either Randall or Dominique speaking will be September 22nd for the general audience, meaning those who are not necessarily yet trust clients, open to the public, although Dominique will be doing her trust study group webinars as well, which we announce in the newsletters for those who already are paid trust clients. And for those who need to look at past videos, go to www.brilliance-videos.com. That forwards to our YouTube channel, brilliance-videos.com. For those who need a phone number, that's 360-200-7521. For those who need a URL, we prefer that you use that of the affiliate who referred you. For those who don't have one, go to house-of-freedom-trust.com. I'm Tonson Fairmont. I'm the founder, consultant in bank instruments programs, speaker on various radio shows, author of a couple of books, one's forthcoming. Randall Hillner is the head of our trust department and has created a legacy already of several decades of service to humanity in helping all kinds of humanitarian projects and families protect their assets and do so in a superior way with great intelligence, creativity, and innovation in the field of asset protection. Dominique Hackett is joining us today. Actually, she's filling in for Randall because he's unavailable today, but you'll enjoy her presentation, and she's going to have some special, very, very wonderful knowledge for us that's different and unusual. You might not have seen this before, so stay tuned. Today's topic is duty of loyalty, part 2. We did part 1 last month, and we will continue with part 2 today. Dominique, I will bring you on and take it away.
Well, hello, everyone. Welcome to today's trust topic of continuing with the duty of fiduciary. And fiduciary responsibility has to do with our responsibility as a trustee. So for those of you considering working with Randall to create a trust, if you're considering the position of being a trustee, there is some wonderful information we can share with you, but in particular, relating to a trustee's duty of loyalty. And so we're going to go through a couple of slides that Randall actually provided for us, and we're going to share. This is part 2 of reviewing the fiduciary responsibility of trustees. So the first, one moment, if you hit mute on your computer, just, and it's still, there you go. If there's a background that you hear, let me know, and I'll adjust the sound. Sounds good. Okay, well, moving forward. So the summary of the principles of trust law in this area, we're going to look at something that was summarized in England by the Livery QC. The QC stands for Queen's Counsel, and it's a title given to lawyers who have a senior standing in the court. So the summary that we're going to review today has to do with some principles that were clearly written out in a case called Hunter Kane versus Watkins in 2003. So this is pretty recent ruling that has to do with actually the breach of fiduciary duty by someone who was a director in a company. And directors in a company, actually, I might know how to solve that, Tanzan, by just pressing on your keyboard, press F11. And it still didn't.
It's blowing my mind. The speaker is off. I've muted it.
Well, I want to double check. Yeah, do you have a second sound? Because I have a second sound on my computer. But if the audience does not, I'm going to continue on. And looks good. Okay, we will keep going. So this case is really important for clearly understanding the responsibility of duty of the trustees and maybe what happens when we're no longer trustee. Is there a continuing responsibility as a fiduciary? So we'll go to the next slide. So the first principle that was laid out by the senior lawyer in this case, he said that a director or trustee, so we're looking at it as trustee, but it's the same fiduciary responsibility. The director, while acting as such, has a fiduciary relationship with the company or with the trust. And that is, he has an obligation to deal with it with loyalty, good faith, and the avoidance of a conflict of self-interest. So just a reminder, a trustee is someone who, if you've only joined us now and you've never seen any of our other webinars, a trustee is someone who has accepted the obligation of holding the title of property for the benefit of the stated beneficiaries. And so, unless a trustee may also be a beneficiary, for the most part, trustees should not derive benefit from the trust assets, other than obviously they're going to get paid a trustee fee. But the goal is that the trustee has loyalty, good faith, and is going to avoid conflict of interest. So what is a fiduciary in regards to trust? A fiduciary is someone who holds power. They hold power over assets, and they must use this power for the benefit of the beneficiaries. So what's the opposite of this? The opposite would be if we hold personal power. So when we hold personal power, we act in our best interest. So a fiduciary is someone who is acting and using their discernment to make decisions on behalf of other people. So that's what the trustee is doing. And why is it that we're discussing fiduciary duty of loyalty, and why are we even having a second seminar about it? It's because it is so important to understand the duty of the fiduciary can take a normal act that for another person would be legal and there'd be no problem with it. But for a trustee, it could turn that act into an improper act. So that's why we look to understand the duty of loyalty as a trustee. So I'll give you a quick example. Say you're a trustee, but you're also an inventor. And say in your private life, you've invented something and you want to get some venture capital in order to pursue marketing your invention and getting it out into the public. Well, as a trustee, it would be a conflict of interest for you to go to the trust and ask the trust to please contribute money to your invention. because there's the possibility of loss. So there's a case where, as an individual, you have an interest, but you need to respect that when you're being a trustee, you're wearing a different hat. And when you wear the trustee hat, the conflict of interest is you're looking towards the trust interest before you're looking towards your own interest. Could we go to the second slide? So the second principle laid out has to do with a requirement to avoid conflict of duty or self-interest. That means that the trustee is precluded from obtaining for himself, either secretly or without informed consent. And we'll talk about what informed consent is. So he's precluded from obtaining for himself any property or business advantage, either belonging to the trust or for which it has been negotiating, especially where the trustee has been a participant in the negotiation. So what this means is, first of all, what is informed consent? So say you have, as a trustee, we're always looking to increase the trust assets. That's one of our responsibilities as a trustee. And you see an opportunity, but this opportunity may have a possible conflict of interest. For example, the venture capital needed for an invention to be made. Informed consent is where you would have a meeting with the other trustees, and maybe you want to even include the beneficiaries. And you would talk to them about the risk of what the investment capital that you're seeking. You'd talk to them about the possible conflict of interest, and you would not do anything in secret. You would be transparent about everything that you're doing, how you would personally benefit, and how would the trust benefit. And then that would be informed consent, where everyone would vote on it, and they could decide for themselves whether this is something proper for the trust to do. So what they're trying to say in law is that if you're doing something secretly and you're not telling the other trustees, and you'd be worried and concerned if the other beneficiaries found out, then that's something that you should not be doing. So that's kind of common sense, but that is the basics of the duty of loyalty and the necessity of no conflict of interest. If you feel worried about being transparent, then that you're considering an act that should not probably be done for the trust. You have to keep the trust interest in mind at all times. Next slide. So the trustee's powers, we have the power to resign. And if we resign from office, that is not considered a fiduciary power. This is very interesting. The trustee is entitled to resign even if the resignation might have a disastrous effect on the business or the reputation of the trust. And what this means is when we become trustees, it's an at-will contract. We are saying that we understand the responsibility and the obligation that we are entering into. And we are entering it based on our own free will. And based on that, our compensation will be our trustee fee. And if we reach a point in our endeavors as trustee, we decide, no, for whatever reason, something's going on and I need to resign, because we entered into the arrangement of being a trustee of our own free will, we also of our own free will can resign. So that's something that's, and it also says that very clearly, the way that Randall wrote his trust indenture, he has appointment pages for when the trustee accepts the appointment of being a trustee. And it says very clearly on there that it is an at-will arrangement. So when trustees do become trustees, the only person who can fire a trustee if something untoward was going on would be the other trustees could get together and fire someone who needed to be fired. Or if you have decided to set up an arrangement in your trust where you have a protector. Randall has also written his trust indenture such that there is a place for the protector. And a protector's only responsibility is with cause to fire a trustee if that needed to be done, and then to assist in the hiring of a new trustee. So, very good. We can go to the next slide. So a fiduciary relationship does not continue after the determination of the relationship which gave rise to it. So what that means is, if you are a trustee and then for whatever reason you are now no longer a trustee, the fiduciary role that you were playing ends after you are no longer a trustee, except for some certain events. And that's what we're taking a look at. So after the relationship is determined, the trustee in general is not under the continuing obligations, which are the feature of the fiduciary relationship. And that makes sense. You're a trustee, you have the duty of loyalty, you have the duty of no conflict of interest, then you resign your position, and now you're acting with your own personal power. So what is it that might possibly throw a wrench in the works? And that has to do with why these principles were all laid out by the senior lawyer of the Queen's Counsel. What happened was this case of Hunter Kane and Watson, the company board of director, before he resigned as being a director, he did some secret things. And he actually arranged for some maturing business interest to not mature for the company that he resigned from. But he did some preparatory moves with them such that they would mature after he was no longer director, and he was then working for a different company on his own. So because of that, this case has been reviewed under a lot of cases, because we're looking at what's the proper way to be a fiduciary. Because a fiduciary is actually, it's an act of conscience. It's an act of good conscience. You are being trusted to care for assets for the benefit of a third party. And in that trust, we need to look at not only protecting the trust, but we need to also understand how we as people work with that trust relationship. So that's why we're reviewing these more esoteric sides of our duty of loyalty as trustees. So once again, we are allowed to resign. And when we resign, for the most part, our fiduciary relationship ends. And that kind of makes sense. Slide number 5.
Thank you for the questions everyone's putting into chat. So along the way, as Dominique is speaking, please feel free to put your questions in chat or write them down. And then when we open up for questions and answers, we will entertain those. Thank you.
Perfect. So acts done by trustees while in contract of the trust subsist. They stay in force, but which are preparatory to competition after it terminates are not necessarily in themselves a breach of implied term as to the loyalty and fidelity of the trust. So what it's saying here is that when we say as a trustee, we help the trust purchase a piece of property. So we are changing the cash that the trust held into real estate. And when we sign the title of the real estate, we are signing our name, comma, TTEE for the trust. That document, even when we resign as a trustee, that document subsists. It is intact. It is a properly completed document that holds the title of that property for the trust, even when we are no longer trustee of that trust. So that's where the acts of the trustee will continue, will subsist after the trustee is no longer there. But what this court case was looking at was preparatory for competition. So this board of director in this particular case had done some acts He even tried to delete them off his computer so no one could find that he had done it. But he had laid groundwork for him planning to resign and then take advantage of this maturing business opportunity in another company after he had resigned. That was the part where the court looked at it and said, wait a second, this part of your fiduciary responsibility seems to have had a conflict of interest. So slide number 6. Trustees, no less than employees, acquire a general fund of skill, knowledge, and expertise in the course of their work, which is plainly in the public interest, that they should be free, and this sounds weird, free to exploit it in a new position. So what this is saying is that the courts recognize all of us are learning something wherever we're at. We are gaining knowledge whether we are being employed with someone or whether we are the trustee of a trust and we're engaged in trust business. We are constantly growing our knowledge base. And that is our knowledge, even though we have learned it as an employee inside of a company, or we've learned it as a trustee inside of a trust. That is our personal knowledge. And it benefits society that when we are no longer a trustee or we're no longer an employee, it benefits society that we continue to grow our knowledge and continue to take advantage of what we've learned in order to do more business or create more ideas. This is a good thing for society, that inventions are constantly being encouraged and ideas are blossoming. This is a good thing. So the things that we learn inside of being a trustee, those are not owned by the trust. So when you are no longer a trustee, the things that you learned being a trustee, you take that with you, and perhaps you're the trustee of another trust, or you have some other business opportunity, and that is recognized by the courts as being totally a good thing for everyone. So, but what isn't a good thing is if you have misused something that you learned as a trustee, and then when you're no longer a trustee, you take advantage of something that creates an unfair business advantage. We hear about this with the stock market. We know famous people who have been convicted of insider trading and so forth. So we recognize as a society that having an undue advantage is not a good thing for society, but having knowledge and making good use of knowledge, that is a good thing for society. So number 7. So a trustee is, however, precluded from acting in breach of the requirement to avoid conflict of interest or conflict of duty, even after his resignation, for this one case where his resignation may fairly be said to have been prompted or influenced by a wish to acquire for himself any maturing business opportunities that were originally sought by the trust, and where it was his position with the trust as the trustee, rather than his own, a fresh initiative that led him to the opportunity which he later acquired. So as a trustee, I like going back to the inventor because it's a simple example. You're a trustee, you're doing things with the trust has a business opportunity, and then you realize, because you're an inventor, aha, this opportunity for the trust, if I had the opportunity personally, I could do way more with it than what the trust could do. I'm going to have a secret meeting with them and let them know that I'm going to resign being trustee, and then give it 3 months, and then I'll go and work with this other company and take advantage of this other business enterprise. That would be a conflict of interest. So what Randall's trying to pass on with this particular seminar on duty of loyalty is trying to say that we grow as people, and our knowledge, our human capital, that is our own, that is personal. But the advantages, the business advantages that we may participate in as a trustee for a trust, we have to be aware of conflict of interest. And we want to stay transparent and make sure that all of our dealings with the trust are of the highest integrity and the highest caliber of actions, where we are working not only for the trust highest good and the beneficiary's highest good, but we also keep in mind that our knowledge is growing and we're benefiting from the position of being trustee. So it's to me, it's a very noble position to take, but it does require the work of continuing your education, learning about business, and based on the assets of your trust, learning how you can help those trust assets grow. And then when you do decide, okay, I need to give someone else the opportunity of being a trustee, then you'll know how to end gracefully that relationship and honor the conflict of interest and the duty of loyalty, honor it in the way that it's best honored, that serves your needs as well as the trust needs. So slide number 8. The underlying basis of the liability of a trustee who exploits after his resignation a maturing business opportunity, and when they say of the company, we're taking that of the trust, is that the opportunity is treated as if it were the property of the trust in relation to which the trustee had the fiduciary duty. So when they're talking about a maturing business opportunity, the courts are, they're not trying to be punitive when they are suggesting the best practice for honoring duty of loyalty. They're trying to say that it would have to be something really obvious. So when you say maturing business opportunity, it's something that's ready to, manifest immediately. It's not like some idea that hasn't landed yet and doesn't have feet under it. They're not talking about that. They're really talking about something very specific. And it is our hopes that everyone who is listening to the seminar and decides to be a trustee, that you will understand this inside of the trust, there are so many beautiful opportunities to learn and grow as a person, as well as helping to grow the trust assets for the benefit of the beneficiaries. Next slide. So unfortunately, this is a commentary. There's actually 11 principles that were laid out in the court case, but unfortunately, the common law rules are likely to have little influence in many cases, simply because what can happen with the trustees is if there is something that appears and might be a conflict of interest, all they would need to do is get all of the trustees together, have a general meeting, vote on it, and then that decision could be ratified. So what I'm trying to say is we're trying to encourage good conscience, because what will happen is if you do something that is a conflict of interest, even though you have the beneficiary signed off, and even though you have the trustees sign off, everybody's in agreement, you can do it, we understand there's a conflict of interest. If there ends up being an economic loss that occurs from the action that you took, you may still end up having a liability that would not have been good to have entered into. So that's really the bottom line of the conflict of interest. You're trying to save everyone from getting into a sticky situation. So what the Randall's comment here about common law. So what's beautiful about common law is it is a body of rules that basically we call it judge-made. People had a contract with someone, they ran into a bump, they couldn't figure out how to answer a situation, so they went to someone who they felt was above them, who they respected. who would issue a judgment. And so over the centuries, those judgments became a body of common understanding about best business practices and so forth. And this common body of law makes it easier for us to interact with one another. It's common sense. But when we talk about trust law, we're really talking about something even more than common law. We are talking about acting with good conscience and holding that trust position of caring for assets for the benefit of a third party, for the benefit of beneficiaries. And so there are things that it may be lawful for an ordinary individual to do, but as a trustee, you may look at it and realize, oh, that's a possible conflict of interest, or that's a possible conflict to my duty of loyalty, and therefore I cannot do that act, even though common law wise for another individual be perfectly fine for them. Do we have another slide after this one?
No, that's it.
That's it. Beautiful. So now we see there are lots of questions.
Dominique, your mind is like a crystal or a diamond with sunshine shining through it, because even I was a little like, what does he mean by this? And what does he mean by that? And you've brought such incredible clarity to those concepts. So thank you so much. Everyone, we're opening up the questions now. If you would like, if you're calling in by phone, press *9. If you would like to, if you're on by video and you would like to speak, just click on the raise hand icon or type your question into chat. We already have some in chat. And JB, your first one is, what if that capital venture by the fiduciary benefits both the fiduciary and the trust? Would it be okay to then enter into venture capital if, let's say, some of it goes to the trust?
So in a situation like that, there are two things that you should do. One is you should create a trust minute that clearly lays out that there is a possible conflict of interest. Don't hide it. Lay it out that it's very clear and that you've had this discussion, because you're noting that one of the trustees is going to personally benefit from an action that the board of trustees is contemplating and taking. So that's number one, you have transparency. And then number two, say for example, it's venture capital and there's a interest for that venture capital. What you would do is you would have 3 examples of something similar where there is a interest charged, and you would make sure that whatever interest is charged for that venture capital is a reasonable amount based on current market conditions. And so you would include with your trust minutes that you have not given any undue ease to the possible conflict of interest. You are following what is actually in the best interest of the trust, as well as recognizing the trustee may also be benefiting. So that's how you document what's happening for you and keep it very clear and above board. So you want to make sure the interest that's charged is reasonable, and you want to make sure that you've clearly enunciated in the minutes that the trustee will benefit, but the trustees, the board of trustees, have decided that is in the best interest of the trust. I hope that answers your question.
Beautiful. Also, is an executor and trustee both fiduciaries? Which one has the most responsibility?
So usually when you're speaking of an executor, you're talking about someone who's handling someone's will. And if you're meaning an executive manager, I'm going to assume that you're meaning an executor, someone handling the will. So when handling the will, if there is a particular terms in the will that the executor, in fulfilling them, the executor is going to benefit, depending upon how much money is involved, that executor would be wise to have the other beneficiaries of the will understand the situation and basically approve the distribution. So this just keeps you out of court. I mean, we may talk about court cases and so forth, but what we're looking at is best trust management practices, because none of us want to end up in court for any reason. We want to have harmonious relations. So did I get the question all the way?
Perfect, perfect. And can you be both executor and trustee? I think that she's maybe thinking of executor as a position in a natural law trust. So you might maybe want to clarify that.
Well, my understanding, executor is only of a will, and there is a case where the grantor should have what's called a pour over will. So there may be a situation where a trustee of a trust, which the grantor has relinquished all authority and responsibility over those assets, but he may also have a pour over will, and that trustee is named in the pour over will as well as in the trust. It depends on how that will is written. If the will is written such that all of the assets are to be treated as though they already exist in the trust, then there may not be a conflict of interest. But if the will is dealing with other assets and you do get a sense of a conflict of interest, it is really good to have a conversation with the beneficiaries and see if you can come to one mind.
There's a chat comment saying my voice is echoing. I think it's going through your mic. So
oh, yes.
Can you read the chat questions?
I can. Not a problem. Okay, I'm going to see if I can read the chat questions. Let's see.
Can you be a trustee and not a fiduciary?
Can you be a let's see? Can you be a trustee and not a fiduciary? No. So fiduciary specifically is the relationship that describes what a trustee is. And so they are one and the same. A trustee, when you classify the powers of a trustee, which Randall has enumerated the powers of a trustee in his trust indenture. So they're all spelled out very clearly. But when you speak of all those powers in one word, the word is fiduciary. And there are different fiduciary relationships depending upon what position you hold. So for example, a bank may be called a fiduciary. Well, in what way are they a fiduciary? They owe a duty and loyalty to their customer to a certain extent, and that's laid out in the bank's agreement. Whenever we open an account, we get pages and pages of legalese that explains the limitation of their fiduciary responsibility. So that's an excellent question. And no, if you are a trustee, you are a fiduciary. The next question we have, I'm just going to read it off. It says, as you say, let's see if I can, oops, now I made it disappear. There we go. There we go. As you say, a trustee of a private trust, a key priority is to protect and be loyal to the beneficiaries. In the scenario where the trust wants to open a trading account, so that we assume that's a stock account, and the trading company requests a KYC, that's know your client, for all the beneficiaries, my answer is that they do not have that right, and any information about the beneficiaries is none of their business. That the information is private and it's not relevant as the beneficiaries are not doing the trading. Do you agree? So this is a tricky one because since 9/11, the banking institutions have upped their requests of information that in the past was respected as being private. And most of it has to do with just wanting to protect against money laundering, wanting to make sure that any funds flowing through their institution are being used for legal and lawful purposes. And I have not had to deal with, I've reviewed the paperwork, but I've not had to deal with a banker yet and say to them, no, you're not getting that information, and then see how that's handled and how that moves forward. I don't know, Tanzan, have you had that experience yet? And I'll put my mic on mute. Tanzan hasn't either. So I agree with you that that information should be kept private, but I do understand that they are asking it for money, for whatever guidelines they've been given regarding money laundering. So I would just work with the banker and say, you know, who do we need to talk to in order to have a conversation? Because that's my requirement of being a trustee, is that I keep confidentiality regarding trust assets and trust beneficiaries. Let's see. Next question. I have a family business, but instead of us being the owners of the company, can the trust be the owner? And how would we go about doing this? That's a wonderful question. So trusts have been the owners of companies for many generations. And right now in this time period, what's usually recommended is that the trust may not be necessarily 100% owner, but maybe 90% or even 95%, but keep a human in the loop. So have at least one person, and then have the remainder of the either membership or shares could definitely be owned by the trust, not a problem. And the way that's done is through paperwork, through the trust minutes. If the business is a LLC, the business would set up its organization and state that the trust is a member of the LLC. If it is a S Corp or a C Corp, you would literally be issuing stocks to, and these are private, you'd be issuing a stock certificate to the trust to represent the trust's ownership in the company. So yes, indeed, that is a beautiful thing to do and has been done for many centuries. Trusts have been owning or partly owning family businesses. Excellent question. Let's see. Following back on another question, he is an executor of a will, but the trustee of a trust. I think, hopefully I've answered that. So if it's a pour over will, which is saying that the assets are all to be treated as though they're already in the trust, that doesn't appear to be a conflict of interest. But if you are worried about a conflict of interest, have a conversation with the beneficiaries. That's best. Then, is it required to give all current beneficiaries a copy of a certificate of units of beneficial interest signed by the trustees, or is it okay just to keep a copy of each beneficiary's certificate with the trust paperwork in the trust binder with the trustee? Or can you give the beneficiaries a copy later after the trust receives sufficient assets? So this is a great question, and we talk about questions like this in our trustee administration. Once a month, we get together as trustees and study best administration practices. I can't tell you legally what is the best thing to do, but I can tell you that those certificates are actually very important. And there are court cases where family members have found old certificates, and it helped prove that they were a continuing heir of a beneficiary and had rights to a trust. So all the paperwork that Randall has put together for our trust indenture, every page of it is very important for caring for the trust, caring for the assets, and caring for the beneficiaries. So if your trust starts out and may not have that many assets, so you're not actually doing any disbursements to your beneficiaries at this time, then it's logical to me that you wouldn't maybe even tell them that they're a beneficiary, because they're not ready to be receiving of anything. It's not, it hasn't really, it may take a couple of years to really get the trust going and get it off the ground. So that's perfectly fine. And then after you get going, it really depends on who your beneficiaries are. Are they family members that eventually you want to hopefully get them trained so that they're running businesses, or maybe they'll become a trustee in the future? It depends on how you've put your trust together and how you're working with your beneficiaries as to whether, when you notify them, and whether they will be holding on to paperwork or not. Now, on the trust certificates for the units of beneficial interest, it states very clearly that these are non-negotiable units, which means that the only place that this certificate is going to go back to is it would get handed back to the trustee if it needed to be reissued in another beneficiary's name, or reissued sharing some units with another beneficiary. So in that case, that piece of paper only means something to the beneficiary and to the trust. So it's not going to be used out in public for anything. It's non-negotiable. So you may decide to just keep the copy in the binder and have a conversation. But that's something that the trustees get to decide, the board of trustees, and then you work it out based on the beneficiaries of the trust that you are the trustee of. Hope that helps. Is the executor of a living estate different from the executor of a deceased estate? Yes. So the executor of a living estate is sort of like a successor trustee. They have a potential position in the future when that person who created the living estate, when they have passed on. So that is a future position. And you should know that if you are named the executor of a will, that is also an at-will contract. You get to choose whether you want to fulfill that position, even though you've been named. So if you decide that you don't want to do it, or you can't handle the paperwork, that's where, based upon the will's assets, you would hire someone to help out, or maybe even you would resign and someone else would be executor. So that's a very interesting question. Then trustee is more title and fiduciary is more function and character. Yes, that's very beautiful. Very well said. Trustee is your title, and fiduciary describes what you do and your character of owing loyalty. Very beautiful. Banks have zero loyalty to their customers. We sure hope that that changes. What if one beneficiary is a foundation in relation to a trading account? So exactly. So we can have beneficiaries that are foundations, that are nonprofits, that are other companies, that are other trusts can also be a beneficiary. So exactly, that's a whole nother reason why protecting that confidentiality is important. And if it wasn't important, you would know more. There would be more private trusts out in public information. Right now, we only find out about the private irrevocable trusts when there's an issue and someone has taken it to court in order to get a ruling from a judge of how to handle a situation. The last one I'm thinking of is Robin Williams Trust. So you can look up and find a lot of information about it because it became public because there was a conflict they couldn't solve. It had to do with memorabilia. So he labeled who he wanted some of his memorabilia to go to, but he wasn't specific. And since he wasn't specific, the beneficiaries took it to court to get a court's ruling. Let's see. how do we convey a home that still has a mortgage inside of it into a trust? And is that possible? So yes, but this is the thing. We're always honoring the contract that exists. So the contract that currently exists is a individual owns a property and a mortgage company has a lien on it. So for the trust to take over ownership, the mortgage company would have to be okay with the trust taking over the mortgage. So what you would do in that situation is have a conversation, because mortgage companies are very used to living revocable trusts being the entity that people want their personal property to be contained within. So mortgage companies are used to working with trusts. They may not be that used to working with private irrevocable trusts. So you just get the ball rolling and just start the conversation and say, hey, I own this house, I've got this mortgage, I want to put it in my trust. Just start it very general. Who do I talk to? Because you want to get to the person in the mortgage company that understands trust and can then answer those questions. So once you have approval from the mortgage company that you're going to title the deed to the property differently, and that the mortgage will follow the title of the deed to the trust, so you're honoring that mortgage, then you're going to have a conversation with your county recorder, which records the title of the property. And based upon how things are done in your county, it's really nice if you can get it transferred in without the property being revalued. But you have to understand, with a revocable living trust, the asset is still personal. Yes, it's in a trust, but that trust doesn't really act like a trust until the person dies. When the person dies, it becomes irrevocable. And at that point, the property revalues. That's what they're used to. So if you're putting your property into a private irrevocable trust right away, you want to talk to the county, and hopefully the property value, maybe it's gone down. That'd be fabulous. But that's what you're going to work with. You're going to work with a quick deed, and you're going to make sure they know it's not a sale. You're exchanging it. You're exchanging it from you as a person into your private revocable trust. And they will help you. They have had to handle these things before. Let's see, the next is, let's see, whoops. Is it true beneficiaries need to be a living natural person? Since our mortgages are in the trust, aren't we the beneficiaries and the loan company beneficiary? And how powerful is a PTO? Not sure what a PTO is.
Pure trust organization.
Oh, pure trust organization. How powerful. Gotcha. I never call the National Law Trust a pure trust organization. That's great. So when you say how powerful is it, the asset protection gained by a trust instrument is based on two things, well, actually three things. Number one, how the trust indenture is written. And Randall's trust indenture is written very soundly. He has over 30 years experience working with trust indenture instruments. It's written in English. It's very easy to use, read, and understand. So that's number one. Number two, how is your trust formed? Do you have an adverse trustee? So is the trust really separate from you as a person? And do you really have a trust relationship? So that's the second thing you need. And then the third thing you need is the actions of the trustees is what protects the assets. So if the trustees are careless with paperwork, don't have trust minutes, and aren't making sure that assets are titled in the name of the trust, then you don't have asset protection. So you need all those elements to make a powerful trust, organization. And then, is it true that beneficiaries need to be living natural persons? No, in that You could have a company as a beneficiary. You could have a nonprofit. You could have a foundation. So you can have other entities other than living natural persons as beneficiaries. And then when your comment about the mortgage, since our mortgages are in trust, aren't we the beneficiaries, or is the loan company the beneficiary? So that gets a little more complicated than what I have the ability to answer. So I can save that question for Randall. And we can see if he can answer that next time. Well, this seminar, we're going to focus on the duty of loyalty of the trustees, and we're going to let the mortgages fly over us for the moment. Let's see. Will this recording be available for replay? Yes, it will. Tunson does this wonderful thing where he posts Brilliance in Commerce's seminars on Brilliance in Commerce's YouTube website. So all of Randall's seminars are available for replay. Can we use silver surety bond to fund a trust? Sure. You can use a silver dollar. You can. This comment has to do with the initial funding of a trust. So in order to execute the trust, you need to have someone who's a settlor or a grantor or a nominee settlor. That's fine. And then you need to have an asset. And so what you're speaking to is the initial asset. If you don't have a surety bond or a piece of silver, $21 is what Randall usually puts in as an initial amount, because you have to have an asset and then you have to have clearly defined beneficiaries. So once you have all three of those and you all sign, well, the settlor and the trustee sign the document, you've now executed your trust. So long as you have an asset that you can clearly define. So the idea is you're taking an asset, the grantor is taking an asset and it's handing it over to another person who is the trustee. So you're creating that trust relationship by handing over the asset. Let's see. With a natural law trust, will we need a CPA? And if so, do you have any references? So a CPA is a certified public accountant. And that's someone who has a 4-year degree in accounting, has worked in a CPA office for 2 years, and then has taken a test. And once you are licensed, certified public accountant, your loyalty is to the public. So there are a number of people, well, and another thing, the CPA organization did a lawsuit, I want to say 10 or 15 years ago, and they won the rights to the name accountant. So now anyone who uses the title of accountant, they can only use that title if they are a currently licensed CPA. So there are a lot of people who have an education in finance and understand trust accounting, but they have chosen not to be CPAs anymore because they want their loyalty to be to the trust rather than having loyalty to the public. Certified public accountant, that's where your loyalty is. So is that required for having a trust? It really depends on the assets that the trust has and depends on the businesses that may be trust assets. It depends on the particular trust that the trustees are managing. And you should know that fiduciary trust accounting is a very different animal than normal business accounting. For one, you don't talk about assets, you actually talk about charges because trustees are in charge of assets. So I would just say that I can't give you a recommendation on that other than if you have a lot of assets and you have a lot of concerns, then you're going to need to get recommendations from professionals to answer a lot of different questions.
Dr.
I'm working on a guide to trust accounting. I'm finishing up a fiduciary accounting course to make sure that I have everything in there. But the interesting thing about fiduciary accounting, you can actually call it fiduciary financial tracking, because the way that Randall has written his trust indenture, he has left a lot of leeway to the trustees about how they will be tracking the financial story of what's happening inside the trust. So Randall's indenture does not have a reporting requirement, but I always caution trustees, at some point, you're going to need to answer questions of the beneficiaries, and you'll need to be able to tell the story financially of what's happened with the trust. So we work on these kinds of things in our trustee study group. And my guide is forthcoming. Let's see. So if I'm at the next one, let's see. The first thing you need to do is, okay. So this is someone's comment about counseling paying property taxes. It's quite a complex comment. I'm going to save that for another time because I don't have anything I can offer in regards to that. But I appreciate your comment.
If anyone has further questions, you're welcome to, if you're calling by phone, press *9 to raise your hand. If you're watching by video, click on the raise hand icon if you want to speak, or otherwise type it into chat.
All your questions have been wonderful, wonderful, wonderful. And I think that the most important thing that I hope that you all have taken away from these two seminars regarding fiduciary, the duty of loyalty, my hope is that you understand that it takes a different mindset. Being a trustee, the mindset is no longer, you're not thinking as an owner. You're thinking with the hat of, I'm a custodian of resources. I'm caring for assets for beneficiaries and also trying to assist that this will get carried on into future generations. So it's a very different it's a very different mindset. And I find it a very elevating mindset, because now your view as trustee can affect every relationship that you have in your life. You can view those relationships as a caring for assets and resources rather than an owning. So I think it's being involved with Randall and with Tanzan and working with Randall's trust indenture. I've just found it to have been so elevating in my life. I'm so grateful. Let's see. Can you explain Schedule 1 in the trust? Let's see. Schedule 1, and what is it for? A schedule of loans and how it works. So when you're speaking of Schedule I, I'm trying to remember. Is this a question from Eric? I think it's a question from Eric. I'm not sure schedule. So technically in the trust indenture, there's not a Schedule I. But in a fiduciary accounting model for a trust, there is a Schedule I. And I could have a conversation with you on that in our next study group. We can go over that, that schedule in more detail.
There is a Schedule A.
Yeah, there is a Schedule A for personal property, and then there's a Schedule B for real property, and real property meaning real estate. So Schedule A would hold your bank accounts, your certificates of silver, notes regarding cryptocurrency. That would be on Schedule A, and then Schedule B would be used for real property. Let's see. Are there any other questions? Thank you.
Dominique, you're receiving a lot of compliments there. Thank you, everyone. If there's nothing else, we can go ahead and wrap up. And again, next open to the public webinar, September 22nd. Remind me when your next one is for your clients.
It will be, let's see, August.
So the trust study group that Dominique teaches for paid trust clients is in August, and you would be seeing the links to that in the newsletter that goes to trust clients, and then the webinar open to the public September 22nd. And for those who were asking about where our webinar recordings get published on YouTube, there's the address brilliance-videos.com, which is our YouTube channel. So thank you, everyone. We'll go ahead and conclude. And what those that look outside dream, those that look inside awaken. Any final comments, Dominique?
Ever so grateful to everyone. It's so nice that the masks are lifting and people are smiling at each other once again. Thank you so much.
Thank you, everyone.